Mr. Laliberte, good morning.
Morning, Your Honor. Good morning. My name is John Laliberte. I'm here on behalf of the appellee, Sue Ellen Hershman-Tcherepnin. She is the wife of the late Ivan Tcherepnin. We are here this morning on an appeal from a decision of the appeals court overturning a decision of the Middlesex County Probate and Family Court granting Sue Ellen's motion for summary judgment. The probate court determined that under the will dated March 13, 1998, that Ivan Tcherepnin granted Sue Ellen Tcherepnin a life estate in the marital residence located at 96 Russell Avenue, Watertown, Massachusetts.
Yeah, what is the effect of, in terms of money, of this life estate? She filed a petition to partition, did she not?
That's correct, Your Honor.
Now, analytically, that would mean the property would be sold, and if she has a life estate, she would get the value of the life estate, and they'd get the rest?
Analytically, that's correct, Your Honor.
And that value was $613,000.
Correct, Your Honor. After the probate court made the determination that she held a life estate, we went forward with a trial, and a determination as to the relative monetary interests in the property was determined by Judge Gibson. The purpose of the partition action was not for her to convey the property or sell the property, but rather to adjudicate the monetary interests of the parties for the purpose of Sue Ellen purchasing the interests of the remaining.
Oh, okay.
Or,
So-
if necessary, if she wanted to, sell the property.
If she wanted to, that's
If she
correct.
wanted to,
That's
correct.
correct. And
Their
that's not her intent.
interests would be 4/5 of $177,000.
That's
But she
correct.
also got 1/5 of that.
That's correct, Your Honor.
Okay. Now, the other side of the coin, if it's not a life estate, it's worth $790, and she's $790,000, the property, more or less, and she's got to pay a lot more money if she's going to buy them out.
I don't think we get there under that analysis, Your Honor, because the decision was premised upon a finding that she held a life estate. If there's not a determination that she has a life estate, we have her right to occupy the premises.
Well, no, I understand that, but the judge made an alternative finding that unencumbered by a life estate, the property's worth $790,000 and some odd change.
Correct. But there
Right.
would also be another finding if there was not a finding of a life estate that she had the right to reside there or the right to occupy, and that was not before
Yeah,
the probate
right.
court.
Which leads to my final question in this area. Once we straighten this thing out, it's got to go back, doesn't it?
I don't believe so, Your Honor. If this court were to determine that the probate court correctly determined under the four corners of the will and giving due effect to all the language in the will.
Well, right, but if we determine the appeals court was right, doesn't it have to go back?
Yes, it does.
Right.
At the time that he executed this will, some of his children were living in the home, is that correct?
One child was living at the home at the
Right.
time he executed the will.
They were all
No.
adults, correct?
No.
Stephan was not yet an adult. He did reside at the premises subsequent.
How old is he? I thought he was 18.
One was 16, and one was
16.
20, and one was 27, and one was 29?
I
Is that-
believe that's correct, Your Honor.
Well, but under the interpretation that you are suggesting, the woman could eject that child from the home, and it seems to me that couldn't have been his intent, and not with the use of the language. I mean, the child or some children had been living in the home consistently, and one at least at the time that he executed the will. And how could it have been his intent to eject that child?
I don't believe it was his intent to
Well, but
reject it,
under your scenario, she could eject him.
She could, Your Honor, but that is not the purpose of the will. The will is, as I interpret the will, and as the language employed by Ivan Tcherepnin, most importantly, was to grant her a life estate. He used the language "so long as," and granted her, and that's the language under binding Massachusetts precedent, to give her a life estate in the property.
But doesn't it follow, isn't Justice Cowan right? I mean, if that's right, doesn't it follow that she would have the right to eject that child?
But the record reflects that that didn't happen.
Well, that
Stephan-
doesn't matter.
Stephan-
We're
well,
trying to get to the intent.
It does in terms of, for purposes of interpreting the will. We look at the language of the will. And in fact, the recognition, if we put the court into the same position the testator was at the time he drafted the will, that he knew at the time that Stefan was residing at the residence. And yet, the language is, the will is completely silent as to the right of Stefan to remain in the premises. And the only person that is granted that right is Sue Ellen, his wife. That, coupled with the fact that the record reflects he wasn't injected.
But he could
Ivan,
have been.
I think we can presume that Ivan loved and knew Sue Ellen and knew that she would do the right thing. And he wouldn't have to put in his will something that was understood between the parties in dictating an interest in property. Stefan remained in the premises for 2 years after his father's death, notwithstanding the language in the will. And the will is meant to convey an interest in the property, not necessarily an agreement as to who was going to relative to the children, who was going to reside in the premises.
How old is Stefan now?
95.
I believe he is 26.
He's the youngest?
Yes,
And where is he living now?
Wait a minute.
I do not know, Your Honor.
Well,
Th-
that's sort of
Stefan wasn't the
immaterial.
youngest, was he? I thought Sergei was the youngest.
Serge was 16 and living, I believe, in Falmouth with Ann Tcherepnin,
His mother.
the mother.
I'm looking for it and I can't find it, but when you're I guess I have two questions. One, you say this is consistent with Massachusetts law. Is there a case or cases that use language that life doesn't appear anywhere in the phrase that have been interpreted to grant a life estate?
Yes.
Massachusetts cases?
Yes, Wilmarth v. Bridges, Your Honor. We cite for the proposition that uses language similar to that you employed by the testator here to grant a life estate. In Wilmarth, the language that was employed by the testator in that instance was, so long as she chooses to personally to occupy and improve same. Other courts, and it's the majority rule, that language either granting a life, using the word life, or some other indeterminate term is sufficient as a matter of law to grant a life estate in property.
Does the software package that he used to make the will shed any light on this? Was there language in the software package that created a life estate that he did not use? And he chose this particular language?
Not to my knowledge, Your Honor.
Do we have is the software package in evidence anywhere?
No.
Another question, and this is not being a trust person. One of the will provisions says, it's Article 17, any specific bequest made in this will to two or more beneficiaries shall be shared equally among them. Does that shed any light on this, do you think? I mean, nobody talks about that, and I just wondered whether that doesn't suggest that indeed, as the appeals court found, there was 5 interests that were equal here.
I don't think it does shed light. Well, my analysis of that clause is it applies to the entirety of the will. You have to read that in also the context of paragraph 4 of the will, which says, to the extent I do not leave any interest in property to my children or grandchildren, and does not mention Sue Ellen, that that omission is deemed to be intentional. Then that clause has language to the extent that if except where my will it disposes property in unequal shares, or words to that effect. If you look at the specific bequests, the property in Watertown was conveyed differently to each either the respondents or to and to Sue Ellen. Each are given a 1/5 interest in the property. Then there's a separate clause in the granting clause, paragraph 6 of the will. It says 1/5 interest in ownership of the property to Sue Ellen, comma, and a right to remain there for so long as she desires. That's a separate grant of a property right in the Watertown property. So I would argue in relation to that paragraph, there is a separate grant or separate treatment of Sue Ellen which takes, or makes that a provision inapplicable for your analysis. Your Honor, the law is clear in Massachusetts. Massachusetts courts are to look at the four corners of will and grant and interpret it and give meaning to all the words of the will for gleaning the testator's intent. You can glean the testator's intent clearly from this will by not only looking at the express language of the will, but also the very structure of the will.
What was the order in which those grants came? Did the 1/5 interest to everybody come before or after?
After.
After. Well, his came first.
Hers
Hers
came
came first with the
With the
right to remain there, and then several clauses later.
That's correct. And each respondent and Sue Ellen received not only interest in the property, but also separate bequests, cash, an automobile, paintings, other property of Ivan. That indicates an intent that the respondents and Sue Ellen take different things from Ivan's estate. If I may. Not only the structure, but then there's a residuary clause, paragraph 14 in the will. There, Ivan says, Sue Ellen and the respondents, they names them individually, share, doesn't use the word equally, but shall share in the residuary of my estate. So he knew when he was drafting that will that if he intended them all to have, quote unquote, the equal present possessory interests in the property, he could simply have structured the will to say, I give 1/5 interests in the Watertown property to Sue Ellen and to the children. He didn't do that. He used separate language requesting the property to Sue Ellen.
Well,
the
he did do that. I mean, he certainly did give each one of them 1/5 interest explicitly.
I agree. But the only person he gave ownership, he used the term ownership, she's the only one to get ownership under his will, and she is the only one that is given the right to remain there for so long as she desires.
And what about the idea of, I think you probably cite a case, but about a defeasible, if you will, life estate? That is, if she seeks to partition, as she did, that, that's indicating she's not any longer interested in that exclusive life estate.
I think we cite in our brief the Libby decision that an action for partition by a life tenant does not extinguish.
No, but I'm suggesting it isn't a life tenant, but or it's she can stay there, but if she chooses to do something inconsistent with staying there, then that particular part of her interest ends.
I don't believe that's accurate under Massachusetts law. Once we make a determination that she has a life estate, then that is not her intent. She intends to reside there.
But if it's a defeasible life estate,
Yes.
Does the act of petitioning for partition constitute the defeasance?
I'm not aware of a Massachusetts or other decision deciding that particular issue.
In any event,
I'm
what that would mean was she couldn't make, assuming that she has an interpretation that it is not defeasible or it's not that it is a life estate, it would mean that she couldn't have that determined without losing all of her rights. And there's no provision that I see in this will that says anything about litigation. Correct?
correct.
Boy, for a smart guy, he messed this up to a fairly well. I mean,
He's
I
a
Googled
musician,
him. He was
so-
very accomplished.
Yes, he was.
Yeah.
Yes, he was. The other issue that, insofar as we believe that the appeals court erred as a matter of law, was to look beyond the four corners of the will, and for the purpose of using extrinsic evidence to alter or amend the terms of the will. The argument is that the testator could not have intended that under the circumstances that the children not share an equal interest in the real property. There's not a single language in the will itself saying that the children are supposed to have a equal interest in the property. Secondly, the appeals court indicated that the absence of remainder language in the will itself was somehow dispositive. That's not accurate under Massachusetts law. We cite the Burnett v. Kivior decision, and in conjunction with the Wilmarth v. Bridges matter, that read in the context that the absence of the remainder language is not dispositive. What is dispositive in this issue is the use of the language so long as. That is what is operative as a matter of law.
You know, it strikes me that the testator here, contrary to what Justice Graney was suggesting, didn't really screw this up. The law is kind of screwy. I mean, it seems to me that if you read this, it's quite plain what he intended. It's the law that makes those words into something else. It's quite clear that he intended she had the right to live there as long as she wanted to live there. And if she didn't want to live there anymore, then the house belongs equally to all five in some sort of final chapter. It's the fact that this language means life estate, which has all sorts of other sort of implications, is what's messed up here, not the plain language. Wouldn't you suggest that?
No, I wouldn't agree with that, Your Honor. I think we give effect to the language employed in the law, and the Massachusetts precedent is to the extent that we give meaning to words.
And we will tell you what the effect of this language is, whether it's what any person ordinarily would mean by it or not.
Agreed, but actually the law here is well established that to the extent that that language is employed, it might have a legal impact that is not what the testator intended.
Well, if we're going to provide some magic to it, shouldn't the magic language be there? I guess that's the...
I suppose another way of looking at this, and perhaps your time, well, why don't I ask this to Mr. Tillotson, Mr.
you.
La Liberté.
Thank you.
Good morning. Diane Tillotson, representing Nicholas, Stefan, Sergei, and Serena Cherepnin, the 4 adult children.
What about the mother? She's not part of this?
Excuse me?
His mother, didn't she also take under the will?
She did take under the will,
And
but she's not part of this because she was left no interest in the real estate that's at issue in the estate.
Yeah. Quite frankly, it seems to me this case can go either way. So the question is, in my mind, is do we go with the probate judge or do we go with the appeals court? You can find cases that would justify either result.
Your Honor, I would respectfully suggest that there are no cases that justify the probate court's result.
Well,
and
can
that's
you distinguish the language in Hazeltine and in Burnett?
Well,
Seems
Hazeltine
similar.
was the case that actually did use language that was quite similar and specifically found that there was not a life estate granted, that it was some lesser, and I think the court used indeterminate interest that was granted by the language as long as she desires to live there. That was not the central issue in that case. However, I would suggest that that case supports the appeals court's decision and not the probate court's decision.
What about the Wilmarth case?
The Wilmarth case, Your Honor, I would suggest is quite distinguishable because, first of all, there are 2 successive life estates provided for, the first to the widow Mary and the second to the daughter Mary. But the daughter Mary's estate is described as the use and improvement of the real estate as long as she chooses to occupy and improve on the condition of keeping in repair, paying taxes, and so forth. The Wilmarth case does not leave, and this is the critical factor, I think, that this distinguishes this case from the present case. The Wilmarth case does not leave concurrent interests to the other children. It leaves concurrent interests in the personal estate. The real estate is left subject to that. It doesn't say subject to, but there is no explicit devise of the real estate to 5 people that hold a concurrent interest. So I think that is the distinguishing feature. There's no Massachusetts case and no other case that I know of where you have a devise to 5 individuals, 1/5 interest, no remainder language, and any court has held that language such as used here, for as long as she desires to, and it's not for as long as she desires to live there, which I also think is somewhat critical. It's for as long as she desires to remain there, which, again, in my view, under the circumstances, facts and circumstances of this case, suggests something else. And,
What's the difference between,
I fail to see that distinction.
what, live and remain?
well, live there, again,
Primary residence versus secondary residence?
well, I think that, again, if you look at the four corners of the instrument, first of all, and you look at all the provisions
That's
in
the
the
only
will,
thing we're going to look at.
and you understand, you look at it in the light of the facts and circumstances of the case. And that's a question I think that we need to perhaps address, and I can see
No, because
Chief Justice
remain there, I'm
Marshall.
not going to say, I've got to go look to see whether she had a second property. Remain there and live there, from my point of view, mean exactly the same thing.
All right.
She can abide there. She can be there. She can stay there.
I don't see why you say that Hazeltine, that the language supports you. In Hazeltine, the words are, real property to the wife for use, quote, so long as she shall desire to reside therein, unquote. And that was determined to be a life estate in the wife.
Your Honor, respectfully, I believe that in the Hazeltine case, it was determined by the court in that case to be something less than a life estate. I think what the court uses is indeterminate, an estate of lesser and indeterminate value.
But
I think
if that's, even if that's true, doesn't that defeat your claim that the interests of the children were concurrent?
I think it's clear from the language of the will that the interests of the children are concurrent.
I mean, I understand what you mean by concurrent in the sense that they don't have to wait till somebody dies, but that doesn't help me in this set of circumstances. You've got language that applies to his wife, which is very different and absent from language which applies to his children.
I would suggest, Your Honor, and let me first go to the language in the will itself that I think supports the children's interpretation, which is there's an additional, in addition to leaving the real estate in equal 1/5, there's also a provision that talks about the house furnishings, and this is also a distinguishing feature from the Wilmarth case. The furnishings are also left, the home furnishings, in equal 1/5 interest. The wife gets first choice, but she doesn't get use of the furnishings and use of everything in the house for as long as she chooses to remain there or as long as she lives. That is very different from the language in the Wilmarth case, where the testator specifically excluded the home furnishings from the personalty that he divided amongst the children who were not given the right to remain in the house. So I think the indication
am I
that
correct, Ms. Tillotson, that under your interpretation of the will, presuming that she chose to remain there, to live there, to abide there, that that they cannot get access to the value of the 1/5 until she dies or leaves?
I think that's frankly a stretch, Your Honor. I think that's sort of pulling an interpretation out that's not there. And I think this brings
what
up
do you think happens that she? What do you think practically happens under your interpretation?
I think that under my interpretation, what the testator intended was...
not what he intended. What happens? That one of your clients can put that house on the market now?
No, that one of my clients could possibly share occupancy with her, and if they didn't, that they would be entitled...
that they can share occupancy? So that's number one. And if they didn't, share occupancy...
Well, again, they're not excluded from occupancy.
Doesn't that render that language useless?
No. Well, again, let me back up for a moment. I think first and critical to the debate we're having is the fact that I think we would all agree that it is less than clear what that language means.
No, I want to understand what the effects of... You're saying any one of them could move in tomorrow,
And if they don't, if they can't decide, either the party, well, I think what she's given is a protection against partition, frankly, a protection against ouster. That's our position, and that's our argument.
So
in this case.
if she says, no, you can't move in here,
I think that the other 4 children are then entitled to some benefit. I think they would all share in the expenses, but that they would be entitled to some rental income from her continued occupancy and their exclusion, because there's nothing in this will that excludes them from occupancy. And in fact, again,
nothing that
the
excludes them
provision
from
that Judge Botsford referred to the extent that they're given equal interest, his intent, as he expressed it in the will, was that they share equally in the real estate. But I think
I think they were, well, in any case.
again, I think the debate that we're having.
It's not a debate. I was simply asking what the effect of your interpretation is.
But I think there's a reasonable question about the meaning of this language in the will, the right to remain as long as she desires.
Doesn't make that it's, the fact that there's a challenge to a will and that people ask questions doesn't turn it into a debate and doesn't mean to say that it's ambiguous.
Right. Well, again, I think it's less than clear. Whether it's technically ambiguous, I think that the fact that he left the right to remain while leaving 4 concurrent interests to other people does suggest.
Well, the assumption that they're concurrent means that you've adopted a different interpretation.
Well, there's nothing, again, there's no language in the will that suggests respectfully, Your Honor, that there's any intent that those interests only take effect.
If there's a life estate, would your clients have a right to move in?
If it were granted as a life estate,
No.
no.
Okay, and would
No
they
question.
would they have a right to claim rent?
No.
Right.
No.
So
And there's no debate about that. I think the debate is whether this
No, I
language
understand.
Well,
is the right life
I
estate.
suppose the 4 of them could get together and say, well, we own 4/5 of the house if we go your way. What's this, got 2 floors on it? I don't know how big this is.
It's a 2-floor Victorian, Your Honor.
Okay, we're going to rent the top floor. That's our 4/5 and pocket the rents. Doable?
not if there's a life estate.
Well,
Well,
no, I say
again,
if we
it
go
depends
your,
on whether or not you interpret
agree
the
with you
language
that
as a
there's
life
no life
estate.
estate.
I think that
No,
that
they
may
couldn't
be
do that.
possible. I don't know.
But
And
in
not as a
your view-
practical matter, they don't have the right to do that.
No, if
Well,
there's not
again,
a
I
life
think it
estate-
depends on whether or not you buy
If we
the
go your
argument
way,
that this
they own
created a life
4/5
estate. If it's a
If we
life
go your
estate,
way,
they don't.
own 4/5 of the house, subject to her right to remain in there.
That's correct. And the question is, I think the real question is that a current interest, or is that an interest that only takes effect after her life estate? And that's the question, obviously, for this court to
When the
decide.
appeals court said that it was apparently the hope of the testator that the devisees be able to agree on the use and occupancy of the property, on what was that based, or was that just speculation by the appeals court?
Well, again, I think I don't think it was speculation. I think it was similar to language that's used by the court when looking at, in trying to interpret documents, wills or deeds. But I believe that what the court was looking at was perhaps the provision that Justice Botsford just cited, that it was his intent that the parties take equally any property that was left to them in equal shares be shared equally.
When he did this, they were all one big happy family.
And they were, and it would
I
be.
know they were, and now they're not.
It would be my understanding or my assumption that that was, the intent. I think that I'd just like to address Chief Justice Marshall's point for a moment that there not be or there's no opportunity here to go outside the 4 corners of the will. And I think in this case, I think there is an ambiguity or a lack of clarity when you look at that language and you compare it to the 1/5 interest that's given to all 5 of the children. And I think that under those circumstances, under our case law, for example, the Putnam case, it is permissible to go outside the will, not for purposes of varying what the testator said, but for purposes of trying to explain what the testator meant by that
And
language.
it's your position that if we do that, we would find that he had an express intent, he had an intent when he did that the children who were no longer residing in the house would be able to move back in at any time?
I think it would express an intent that again, I think the circumstances that you look at are not circumstances of...
No, I'm just asking, because that's what you're telling me they have the right to do, and they have to be paid rent. So he had in mind that his adult children who had moved out would be able to come back in with their children at any time, and if she said no, that she would have to pay them rent?
I think that Justice Graney is right. What his intent was that they would continue to get along.
Get along
And-
doesn't
Well,
doesn't
I
define
know,
doesn't
but-
define no doesn't define what
Yeah,
he
that
understood the rights to
That
be.
they would have access to the house if they wanted to come visit with their kids, grandkids.
Not visit,
Yeah,
not visit, to come and live with their children and grandchildren. That's your
I
position.
don't
And I
think he
think
thought
that
it
that's
through
right,
that
but I
far.
think that what he really intended by that language is that he knew that he had 4 children. It was a very recent marriage at the time he executed his will, and that he didn't want to allow his children to essentially oust his
Aren't we
new
talking
wife
in
from the
practical
house.
terms here of-
I think that's what that language meant.
Aren't we talking in
Well,
practical
precisely, and that
terms?
is generally translated into a life estate,
Mm-hmm.
because otherwise they have the right to come back in. A form of ouster, Ms. Tillotson, is when 3 children decide. I mean, the hypothetical about move up to the second floor. A form of ouster is when 3 children decide, because they're not happy anymore, to move back in.
That might
Your
be
Honor,
distressing.
but I'm not. I don't think that is a form of ouster. I think that that's a form of the sharing of the estate
Aren't
that
we
the testator
talking
had in
practically-
mind.
Practically here, that there's got to be a partition. This place has got to be sold if we go your way.
Well, I think in either event, Your Honor, there's a partition. I mean,
But a partition doesn't necessarily mean sale.
Well, it doesn't
if you
necessarily
go-
mean
if we
sale,
go your way.
although I think there's some lack of clarity about the law in terms of what would happen in any event. And again, that piece has not yet been adjudicated by the probate court.
Could you address the question whether there could be or is any possibility of something like a defeasible life estate?
Your Honor, I would respectfully suggest that to the extent, I think there is such a thing as a defeasible life estate a defeasible estate usually relies on words such as for so long as or as long as. And I think that a life estate in and of itself would not be a
well,
defeasible interest, but what is indicated here could be viewed as a defeasible interest.
So if it's in fact a life estate, we're not talking about a defeasible life estate. If it's something short of that, you're suggesting it's a defeasible interest. and
Correct.
It could be defeased by the desire to not live there anymore.
Correct. I'd just like to add one thing. I know my time is out, but getting back to Justice Greeney's very first question of my colleague, it is clear to me that whatever, and it is our position, that whatever the testator intended, if you do the math in this, if you look at what the probate court judge determined were the relative interests, the children would end up with approximately $35,000 versus approximately $650,000 going to the testator. The 4 corners of this instrument,
To the wife.
if you
You
assume...
said testator, but you mean wife.
I mean,
Mean the widow.
his widow.
Widow,
I'm
yeah.
sorry. Thank you very much. Versus the $650,000 left to his widow. And looking at even the 4 corners of the instrument, there's no suggestion that the testator meant to distribute his estate in any other way but equally to his 4 children and to his widow. Thanks
Thank
very
you,
much.
Ms. Tillotson.
Thanks.